pretty eye. Goddamn. Goddamn. Sooner or later, I'm gonna have a goddamn pretty eye me take though.
Damn, so you doing another song for pretty eye?
I can't deny her though. She's my bestie. She's my bestie. That's my bestie. Your para eyes had me paralyzed. Toxic nigga, but you made me to a better guy. Smoke, but with you on forever, ever high. Can watch you all day, girl, like you televised. They like this nigga, they ain't never lied. I lived the bitches alone, I had to pick a side. Look in your eyes, girl, you were hypnotized. Of course, it was your breasts, hips, and them damn thighs. Close my eyes, I'm still mesmerized. To get mad at my bestie, I tried. That's my bestie. My pretty
I heard she's the one, she's got it going on. That's my pretty eyes, baby. Yeah, yeah. She don't take no mess. My bestie is the best. That's my pretty eyes, baby. Yeah, yeah. I heard she's the one, she's got it going on. That's my pretty eyes, baby.
Hey, what's up, everybody? Sorry, I lost track of time and I'm a little late, but it's okay because, we're going to be waiting for verdict and what else. But anyways, Cardi B is on a civil trial. She is being accused of assaulting, scratching the face of Amani Ellis and spitting on her, and causing her emotional distress and all that good stuff. But people say she's lying. So we're gonna get into it, and we're also gonna see what color wig Cardi has on today. So let's dive in. Let's go.
Intent to cause extreme emotional distress.
Well, first of all, so those two points, 1 and 2, are taken directly from the case instruction of self-defense.
Correct.
So
The
point here is that if the jury is going to find that Ms. Almanzar acted in self-defense, then allowing a claim to be stated by pleading it as intentional infliction of emotional distress would be an end run around the fact that she was acting in self-defense.
All right, over here.
Yes, Your Honor, I agree with the court that it is confusing, and I would ask that this will not be submitted.
All right, I'm going to refuse special instruction number 5. All right, and then 3903, we just corrected that?
Yes, that's correct.
All right, that's how I gave it, and so I'll just swap that in. I'm not going to give it again.
Your Honor, I also submitted 3903.
And what does yours say?
It just basically says medical expenses past and future.
I think that is the proposed instruction.
I recall theirs to be a little bit different.
I don't even know why you're trying to put in stuff in there, sir. You haven't even proved your case.
Oh.
Which is
Well, whatever.
the next stage in my binder that was given.
You never know. There could be some Cardi B, haters in the jury. You never know. With 12 or 9 people, whatever.
Because I do think it's confusing, but since I've already given it, I'll just swap in 3903 and 3903A as already read, because I did already.
So you're going to keep the one that's been read already, is that what we're saying?
I did give these jury instructions. I gave them as they're printed out here. It's just without the, I think, the proposed.
Oh, does that hurt you,
instructions
sir?
struck out. So
Cry, baby.
Okay, the one that I submitted this morning is directly out of the
Gosh.
But you combine 3903 and 3903A. And that's not how I gave it. So if it had been given to me that way originally, I would have read it that way, but I didn't, so I don't want to change what I've already read. All right, 3905A. I think I already gave a version of that as well, right? Or maybe I didn't.
I'm not sure, Your Honor, you asked that we just include the case instruction rather than a special instruction. So this is just the case instruction.
Okay, so I will give that.
Your Honor, I also submitted a 3905.
You just read the brief, the
Exactly.
jury.
Straight from the
I mean, the
case.
jury. What
Okay.
Are they
what the jury needs to do.
All right, 3934. That was not in the original package.
That was in the original package.
It
Your Honor.
was.
It was modified only because now that the damages are more limited than what Mr. Rosenthal was proposing earlier, we've just changed the last sentence.
Why you guys going and changing the instructions
Oh,
after
okay.
you read it? That's so
And I did not
dumb.
read that on Wednesday.
You really are trying to confuse
Is
the
that
damn jury.
I don't believe.
I've noticed that.
correct?
Okay, so I'll give 3934. Special instruction number 8.
Special instruction number 8, there are just two differences from the Casey instruction. The first is that punitive damages cannot be awarded if there was accidental harm. The second is to include that's paragraph 3. Paragraph 4 is to include provocation as part of the jury's consideration of punitive damages. And we've identified
Cardi's not even there
a
yet.
lot of supporting
I wonder what
authorities
time
in
Cardi
this.
is coming in. Shit.
And I believe even Wittgen states that it's
Or
proper
is she
to
there and I don't see
instruct
her?
the jury on provocation when they're considering punitive damages.
It's like, let me sleep in a little bit because, I do have 2 kids,
My understanding
three
was
babies.
the trial would be bifurcated, and we would only get to this point after the jury made its decision as to the first non-punitive damages stage.
Well, this is a modification of the Casey that is given during the first phase. So do you want to be heard on the modification, specifically accidental or heat of passion?
Again, Your Honor,
I thought this was all going to be done so they could do closings
there
and
is a
get it all
specific
done with.
Casey on
Your
punitive
Honor.
damages that can be read.
I understand that. He is suggesting that
You're not telling them. You're not putting your foot down, sir.
accidental harm and heat of passion. Do you want to be heard on that?
Yes, Your Honor.
Hello?
So, my point is that none of the cases should be changed. This is an example of one that's really so far off and completely different than what the Casey states. Position.
I think she needs to pay freaking for Cardi's waste of time being in this court.
All right,
That's what I think.
Yes.
All right, I think special instruction rate is appropriate, so I'll give that. Special instruction number 9 is going to apply until we get to punitives. All right, let's go through plaintiff's proposed instructions.
Your Honor, there's one more I need to add, 3932 life expectancy. I have it here.
Well, you're not even going to get it, sir. So I don't know why you want to keep on adding shit.
May not be. I'm willing to reduce it if that's the case, but I believe it's close to the number. Oftentimes, we'll have a stipulation with counsel, so if they want to reduce it to 40 years, I'm fine with that. I just picked a close enough number.
So what evidence do you have that she will continue to have future? I guess she testified that it still bothers her. Is that
Yes, Your Honor.
okay? Any objection to 3932?
Yes, Your Honor, I'm not sure that she testified that it still bothers her, but in any event, first of all, this was never shown to me. We're not sure that the math is correct. And this is just not an appropriate, this is not an appropriate instruction in a case like this where it's over an alleged scratch.
That's right,
There's
Cardi attorney. You tell him.
overwhelming amount of evidence that it
Tell him
was
you're not
caused.
going to try to swindle your sleazeball attorney way into
So
trying
I'm
to
pretty
get
confident that
get
if it
something
was
on your
changed
side.
to 40
Shit.
years, it would fall well below the threshold of the National Violence Statistics Report. So I'm
Jury
willing to do
instructions
that.
are so boring.
If there's a different number that they
Chop, chop.
propose, I'm fine, but there
Chop,
should
chop.
be some kind of case.
The
in
jury's
39,
waiting,
32
sir.
Of life expectancy so that the jury can understand that.
The jury's waiting, sir.
Where's that chart?
Can't take you nowhere.
Oh, here it is.
It's
That's cute. He thinks he's going to win. That's so cute.
And she's 32 today?
yes, she's 32 years old. Yes,
What if
she
they
is.
don't agree? Then it's like a mistrial, or what? What happens if they don't all agree?
This is 50.3. They've got 50. All right, I'll give 3932 over plaintiff or defendant's objection.
Thank you.
All right, plaintiff proposed 3901. I think I already gave 3901. Is that not correct?
If you were so unsure about the jury instructions, why did you start
No, I
reading
gave
them on Friday?
3900. I did. Oh,
Sir?
Your Honor, I
yeah. So 3901 is only if liability has been established, not contested.
I apologize, that's an error.
Okay, so that's withdrawn?
Withdrawn.
Okay.
Yeah, so get rid of it.
3902 already gave. 3903. I did not give, but I think that was proposed by the defense.
That's correct, Your Honor.
And that's the defense version was straight from the casing.
Yes,
Now,
it's in the binder.
the one that I did, Your Honor, is from the case.
Oh, shut up. He's not talking to you. He's doing something. Ding-a-ling. Your Honor, I'm more important. Your
Yeah, I already
Honor.
did give 3903.
Your Honor.
We're gonna go with their version then?
It's straight from the casing. 3905, I think I already gave.
Yeah, you heard on that, Your Honor?
Go ahead.
So the one that I've submitted today has all of the different.
Oh my
types of
God, shut up.
physical pain, mental suffering, and emotional distress.
Oh, she
Their
ain't
version
getting
doesn't
that.
really cover everything at all. It just has a small amount.
First of all, it's your job. And second of all,
It's missing.
you're only suing because
entire
it's
paragraph,
freaking a famous person.
at least a portion of it. So I would request that.
I was her
Wait,
fan. No, you weren't. No, you weren't, bitch.
I just looked. I did not give 3905 on.
You were just looking for a come up. You don't care.
Plaintiff's is straight from the casing,
Yes, sir.
and defendant had a different one.
I think theirs is 3905A, so maybe that's why. But I would like 3905.
Your Honor, I believe the difference is at 3905
Man, I was
and
gonna
3905A. We just submitted them as separate
my
instructions.
thing from
Plaintiff's counsel has combined them.
from
Your Honor, I don't think I've combined
From-
them.
Dee Dee. I gotta do my little things, like my little thing.
Oh, I see. The defense proposed version does not define.
Where the hell's my phone at? So I can cut it up.
Doesn't
Give
cover.
me
Yeah,
my
it's not the full
phone.
instruction, so I'll give plaintiff's proposed instruction.
Thank you.
All right, 1600. think I gave 1,600, didn't I?
I believe you did.
I thought the court wanted us to work on the 1600s.
Come on.
I made a mistake.
You're here, I'm
It
here,
was
I'm
at the
here.
1602 instruction, which was the special instruction
I'm late, but I'm here.
before we discussed earlier.
I did give 1,600 already.
I'm gonna cut up this thing so I can show it from Didi.
Okay.
Let me see here.
1602, did we give a version of that?
What was it called?
1602 is-
I need to go there.
The special instruction 4 that we discussed a few minutes ago.
And that would,
And I need
so
to
I'll give
go
the modified version.
there.
Thank you.
1603, did we give that?
Taking forever.
1603 was included in ours as well. I
Come
believe
on.
the court asked that we include it, so
Okay.
that's in our record.
And 1604,
I believe was given.
was already given. All right, tell me we have an agreed upon verdict form.
Unfortunately, we do not, Your Honor.
Can you highlight the differences?
Well, yes, Your Honor. So I've never seen it the way that they proposed it, with the preponderance of the evidence language. It's also something that is created as a form that doesn't really reflect any type of special verdict that's really I've seen in any case before. I'm not sure what that is. So the one that I've done, Your Honor, I've done two different ones. The distinctions of the two that I submitted is page 7 is added with respect to punitive damages. And the other version does not have the punitive damages. Question number 19. That is the only distinction between the two versions that
You
I
son of a
filed
gun.
with the court. I did give a courtesy copy to counsel. It was filed today at 12:19 a.m. with
Oh,
two
hurry it
different
up,
versions.
dude. I
I
wanted
did give
to
it without, I did submit it to the court this morning without the caption of the attorneys, just so it would be somewhat of a neutral form. And I request that
keep
one
on
of these
doing
be
that.
used, because the one that they've provided doesn't really follow the usual method. It does, I don't think it even has a signature line. Let me see. No, I withdraw that, but it doesn't really cover it the way that's usually done from what I've seen. Thank you.
All right, so I noticed the plaintiff's version has damages for each cause of action, which is duplicative multiple times over. It also doesn't include self-defense, and it also doesn't include what was the other affirmative defense?
Contributory negligence.
Oh, comparative.
Yeah,
Contrib went away a long time ago.
thanks.
All right.
I can modify it.
Your Honor, if I may.
Yes.
What we submitted was to simplify the form as much as possible. I believe it even has fewer questions than the plaintiff's form. And that was after our discussion that the previous form was complicated, which we agreed. We believe this is clear cut. It includes all the issues. It should not be difficult for the jury to understand or to answer.
Shut up, you crybaby.
Go ahead.
So the worst part of it is again states by a preponderance of the evidence. That's not usually in a special verdict form. They put that throughout the questions, kind of limiting, kind of creating a way for the jury to think ahead of time. It just doesn't make sense to have that there. I can modify mine. I have a printer. I can make changes in a couple of minutes and print out the version the court wants me to print. The special verdict that I've submitted, I've seen all kinds of attorneys use it. I've never seen this version. And they would have to change it anyway because of the preponderance of the evidence, and it doesn't really tell the jury how to move along. So, for example, under assault, you have a question, yes or no, and then it says if you answer question 1 is yes, then answer question 2. If you answer no, then proceed to question 6. Theirs doesn't have any of that. It's very confusing and
Oh my gosh.
preponderance of the evidence language. So
You don't have
definitely
no
I would ask that
preponderance of the
language be taken
evidence,
out.
dude.
Preponderance of the evidence.
Oh wait,
You
it's
follow more-
Cardi's. For an attorney, better
more
watch how
along
you
the
are.
lines of the
Okay, you
special
sound like the whiny attorney. I'm just saying. Like,
possibly make it a better
I gotta
form,
pay
but still
attention. I guess.
confusing.
How do I do this?
Your Honor, as far as the instructions, it's just clearly not true. The verdict form specifically states what the jury is supposed to do after they answer every question. There are other problems with plaintiff's form that would be beyond just little modifications. As you mentioned, the damages issue is very likely to lead to confusion and possibly duplicative damages awards. So if the court is inclined to ask that one of these be modified, we believe it should be this one. And we would, if the court has an issue with the preponderance of evidence language, we can strike that language. Otherwise, it would be the same.
Can you strike it and print it within
Yes.
the next 5 minutes?
I can't.
Certainly in the next 10 minutes.
Be heard.
Go ahead.
So again, Your Honor, the way that they've had it is not the way that the Casey instructions read. The Casey instructions do not have these boxes. It's a confusing way. It doesn't allow the jury to really answer the question. They have to just say yes or no for everything. It doesn't break it down. So for example, they're not able to answer the 4 parts of the question. For example, assault, it has 4 parts. And their form does not have
4
the
parts.
ability. The jury cannot answer the 4 different parts. They have to either go with everything or nothing.
Oh,
And that's
dude.
not how the
Wow.
verdict form, or any
Oh,
verdict form.
I'm tired of hearing your
It's not.
crybaby shit.
So I have
Well,
Richard with me
you
today.
know, Your Honor,
I
I'm
can
really
make
just
changes.
trying to get anything
Email
I
it to the
can at
court.
this
The court
point.
wants to
Yes, tell us that.
do something
Go
with
ahead,
it.
tell us that. 'Cause you suck
Their
as an
form
attorney.
doesn't
What's up,
cover
room checker?
any of these questions. For any of them. Either it's all or nothing.
Can you know
And that's
any
not
of
how a
these
special verdict form
questions?
reads. So I ask
Wow.
that the court
I
allow
mean, I'm just inclined to do a general verdict at this point.
Such
I'm willing to
crybaby.
accept that. If that's what the court wishes to do, but theirs is really off base and it does not cover all the 4 parts.
Your Honor, there's multiple causes of action.
Here.
Affirmative
Oh,
defenses that apply
right.
to some causes of action, but not others. We believe it's important, at least for our appeal rights, among other things, that we have a special verdict form in this case. I'd be happy to work on it.
Well, I mean, actually, I think the defendant's proposed verdict form is the equivalent of a general verdict.
Well, may I be heard, please?
Go ahead.
So again, I'm looking at my form here and
Oh,
first of all, the question is, are we doing the punitive damages question? At least if I can narrow it down to, does the court
well, you're
want
not
to do
getting
19?
anything, dude. I don't know why you.
Well, I'm not inclined to do the plaintiff's version at this point.
No, I understand, but I just want to know.
Punitive
if you want
damages.
to have
I'm really
punitive
hoping to
damages
get paid, Your
with that
Honor.
question, because the
I
question
really am.
is saying,
Yes, slim ball attorney.
Your Honor, under the motion to bifurcate, the jury decides entitlement to punitive damages.
Exactly. So here's my question on punitive damages in the defense's proposed version. You've got punitive damages attached to negligence. Was that your intention?
Along with the instruction that it cannot be caused, that punitive damages are not awardable if the conduct was by mistake.
I'm sorry, you said you can get punitive damages for negligence?
No, not if it's by mistake.
Not if it's what?
No, we don't believe you can.
Okay, so but you do have a punitive damages question linked to question number 9, which is damages for negligence and comparative.
We can strike out the end of that of 12.
Okay.
Question 12.
It don't work.
Here's what I want to do. I think the defense version of the verdict form is, for all intents and purposes, a general verdict on each cause of action.
Thanks for letting me know.
I think it's straightforward. I don't think it's confusing. And so the only remaining issue that I have with it is that you've got damages for each section.
Oh, I was adding that.
Whereas there's a jury verdict that says that they only decide damages once. So how do we deal with that?
So we did it. We did the form this way just to avoid having to ask questions like, did you answer question this? Did you answer question that? However, if you look at question 7, for example, it says if you already answered question 4, which is the same, skip this question. So the intent is to have only one of those be answered. And if you fill the form out, that's how it works.
May I respond?
Go ahead.
Each cause of action can have its own separate damages. And that's why
Hey,
in their
Vibrant.
form it is the way that they have it, and that's why I did the same thing. So I would request that
You keep
the
adding
jury
shit
be
in there.
allowed to
You're
break
gonna
down
confuse
on
all
damages.
the whole
Sorry.
damn jury, dude.
what type of damages are for assault. and
None.
battery,
None.
kind of coupled together.
You don't get none, sir. None.
And then intentional infliction.
'Cause there was no
emotional
assault.
distress.
Fuck out of here.
And that arguably kind of makes sense to me. Let's say that they find that the assault was limited to the scratch and nothing more. That the scratch itself did not cause.
No, not even the scratch.
maybe
Come on,
it's
give
gonna
me a
cause future
break.
emotional
Not
distress.
even the scratch.
But they find that the intentional infliction of
Your Honor.
emotional distress was
Your Honor. Not even the
more
scratch.
longer lasting.
See, I blame them for this kind of crap.
For example, Your Honor, have you heard?
Go ahead.
For example, they may find that there was an assault and battery. And
Well,
no
they can
intentional
against
infliction
it.
of
Well,
emotional
thank you. I
distress.
appreciate you.
By removing the
Too much.
damages section, they would never be able to award any damages.
Oh, you want to see a magic trick?
That's why I request
Woo!
that at least be left there so that they could give damages to
I
the
found that
parts
out
they
today. You can switch sides
wish
now.
to give, and counsel on both sides can argue duplication, don't give it twice.
Not
break it
even
down.
not even to go to Olive Garden.
Your Honor, that would be incredibly complicated, difficult to separate. It wouldn't work. I understand your position, but there needs to be some way of ensuring that there's not duplicative damages awarded.
Remember, they have multiple attorneys on their end. They created this form. If the court is going to go along with their form, then they should have to live with the form that they
Oh,
created.
I'm so glad I
The
won't
form
be
that we've created does not have that risk of duplicative
freaking
damages.
mouth. You know.
I'm sorry. The other thing is that
Oh yeah, I
I
was
think we've
gonna
already established with the jury
figure out
instructions
my
that there
damn-
are not damages that are
why am I
awardable,
on something?
under some
Some
causes.
bullshit. Bullshit.
And one more thing.
Bullshit.
I'm sure the court has seen in many cases where it is broken down. There's The damages award specifically for one cause of action, like in this case, assault and battery, and another one for intentional infliction of emotional
No,
distress.
up the road, Toad.
In closing argument, counsel obviously can
You're a
argue
jerk.
how this form should be
Face.
filled out, and as confusing it is to
Okay.
me, I'll have to
Right.
just live with it. But to take away the damages section in assault and battery would mean that it's too confusing. It should be
Does any of the links work?
separate so that
Come on, let me
the jury
do
can
it.
decide whether there should be any damages for assault and battery and any damages for any other cause of action.
Hold on. Can we get on with this BS?
Your Honor, we could, in theory,
Oh,
have
let me
one
hold on. Let me
question
stop
for the
until we
damages and
figure
just
out.
not duplicate them.
So supposedly Cardi B, when she was 4 months pregnant with her first child, this was back in 2018. Cardi B got off the elevator. She seen a security guard following her that was on the phone and said, "Oh my gosh, Cardi B's here!" You know, fanning out, being a fangirl. And then when Cardi turned around and she goes, "Are you security? Why the fuck are you recording me?" You know, like we are in a doctor's place, doctor's towers. Like, why the hell are you filming me? And girl kind of started with her and was like entrapping her basically because she couldn't move. Her back was up against the wall. Supposedly, Cardi B scratched her and she had some scratches you don't see, and then she had 2 treatments of micro needling that she could have done at home for what, $17,000, and then she decided that she's got emotional distress, and then she's gonna add on that Cardi B spit her in her face. And eyewitnesses of that day said that they didn't see no scratch on her nose. Actually, there was only one person that was hurt, and that was the girl that mediated in between them, getting them, away from each other. So nothing like that would happen, and she ended up getting got. And let's see what else. Also, Cardi B had a psychiatrist check her out, and come to find out she's been malingering and she's over exaggerating. All this stuff came up on her test. So I don't know why this whiny dirtbag head attorney over here on this side thinks he's winning anything and wants to add in all this extra stuff when the rules or the jury instructions were read on Wednesday. They were read on Wednesday, so I don't understand why we're adding stuff in. And all he's saying is like, hey, on Cardi's side, can you add just this one instruction that we didn't put in there? And other than that, and then he's adding like 3, 4, 5 different things, trying to get anything. And the only thing they're saying is, hey, we don't even think your math is mathing. And then he goes, well, for punitive damages, because they said that she needs future treatment. Well, she didn't testify to that. Just because her plastic surgeon testified to that, of course they're going to say that to try to get more money. This case is a dumb case. It should have never went to trial. It's bullshit. And, homegirl recorded Cardi B, and she knows she did. She tried to sell that tape to freaking TMZ. Let's be honest. But TMZ didn't want no part of her HIPAA violation bullshit. Because that's really what she got fired for. She lost her job because of a HIPAA violation. It had nothing to do with Cardi B. And if you're that distraught over somebody getting in your face, then you shouldn't have been a security guard in the first place. If you can't keep your cool.
And that's
the way I look at it.
The only difference there would be we would have questions.
And 24 million.
Did you answer yes to the question?
That too.
Did you answer yes? Like what we did with the punitive damages. That would be one more difference.
So that's what I'm wondering is do they put a fixed price on that? That's the only thing I don't understand about civil trials, like civil, the civil part. I mean the punitive damages or the damages and all that stuff. I don't know how the hell she came up with $24 million when girl, you don't make $24 million. Like you didn't lose out much. I mean, yes, you got fired, but it's because of your own bullshit. Like Cardi didn't even report you. The people at her doctor's office reported you. You know what I mean? Like, geez. Just crazy. Absolutely crazy. And then her attorney's like, oh, well, didn't your security guard say that sorry to Miss Amani Ellis? And she's like, I don't know. It's not like I tell him and talk to him and tell him, hey, go put your nose where you didn't see shit. So why would he even say sorry? Like, duh. So dumb. Right.
How about we modify
She was
question 7? What are Miss Ellis?
This came out. She was only making $13 an hour at that job. That doesn't equal to $24 million. You're trying to say you got your feelings hurt because you lost your job because you broke the rules? It's so dumb. Like, people are dumb. Anyway.
If you answer question 4, only include
Okay, where's my word?
additional damages for this cause of action.
Can we include if any, Your Honor?
If any.
I'm confused. So again, it is very confusing because assault and battery is a separate cause of action and has its own damages component. By leaving the form as is, the jury can then decide if they're going to give any damages for assault and battery.
They can, it's under question 4.
Right, in 4. And then they can do it again for 7. They can do it again for 9. They might not do it in any of them. So that way they're able to break it down and decide what, if any, damages they're going to be awarded. Each cause of action has its own damages award.
But you can't double count.
I'm sorry, Aaron?
You can't double count though.
Double count, what does that mean?
Meaning include the same emotional distress that if they find that she has a certain amount of emotional distress, are you asking them to allocate it between the different causes of action or just?
No. I'm just straight asking assault and battery. This is what it is. If you find that an assault and battery, it should really be separate. Now, let's say we take it as together.
It really shouldn't be none, dude.
And then what are the damages for assault and battery?
Oh shit! What
It's
what
really
is
harmful
it?
to have
Like, I gotta see that.
assault and battery combined because the swing that was taken was the assault and the cut to the face was the battery. So we're then limited to one damages, and number 4, we're limited to one set of damages for both assault and battery. So then in my closing, I have to explain that. Same thing, intentional infliction of emotional distress. Separate cause of action, it has its own damages. Negligence has its own damages.
Your Honor, I believe that, first of all, the addition that you proposed would address that. Not including something or just including more damages questions would make everything more complicated. Another proposal, Your Honor, however, is we could do separate verdict forms, one for and have damages only after liability. It would make things less complicated.
Go ahead.
So yeah, separate verdict form complicates it even further. This is a form that defense has prepared. It was well thought out, and it doesn't even break down the 4 different parts.
What are you going to
of the
complain
question.
about again,
If we're
dude?
gonna live with this, I ask that at least we have those damages for each section. I'm not gonna ask for the same thing 3 times. It's gonna be broke. If I'm gonna do it, I will break it down. this is worth this, the other is worth the other. It's not the same, Your Honor. So I asked that the form we submit it as is. And just, if the court is gonna go along with their form, then at least I would ask that. Thank you.
All right, I'm gonna ask that you modify question number 7 to, if you answered question 4, only include additional damages under this cause of action, if any.
All right, that makes sense. Thank you. And what happens with the other one, Your Honor, number 9, same thing?
Same thing.
Hurry up! I want to see Cardi, mofos.
Yes, Your Honor, thank you.
All right.
And Your Honor, will we be giving number 13?
I gotta
Yes.
go to my channel.
Your Honor, just to confirm, question 12, we're going to omit the last 3 words or question 9.
Correct.
Thank you.
Oh shit!
All right. There's a
What's your
judicial notice
title?
regarding the date of the NDA
Okay.
meeting.
Hood, will you
Yes,
check this
sir.
for me and
I
see if
did
it works?
file that yesterday, and I served it a copy on defense counsel.
Or I can do it.
And I'm sorry, what was the testimony of the date that the photograph was taken?
Oh, it works
This,
there.
Almanzar stated that that the photo was taken on the date of the NBA All-Star Game, which was the date of the accident, the date of the incident of February 24, 2018, about 6:30 p.m. She testified that that's when the photograph was taken, and her nails looked like that on that date. There's no question that the All-Star Game was on February 18th of 2018, so it's just a clarification so that the jury is clear of when the game is. This is common knowledge. There's no question about it. I've given different exhibits confirming that the All-Star Game was on February 18th of 2018, and that's why I found this.
All right. Any further defense?
Yes, Your Honor. What Mr. Rosen is saying is absolutely false. I'd like to read what my client testified to. Cardi, I'm going to put this in front of you. Cardi, can you please look at this photograph and tell me, do you recognize this? Answer, yes. Question, what's this photograph? Answer, that is me out here in LA at the All-Star Weekend in
Okay.
Question, does this picture refresh your recollection about what your hair color was that week? Answer, yes. What color was it?
I'll have to put it in my
I'll say like
my
More slowly.
description later, or my
answer. I'll
about
say like an ashy, dirty blonde.
and change it.
Question, can you see your nails in that photo? Answer, yes. Question, were you wearing acrylic nails or some other
Well, I
type?
know what I.
Answer, acrylic. Question, I think you testified yesterday that acrylic nails can last you up to 2 weeks. Is that right? Answer, yes. Question, are those the nails you had the entire time you were in LA? Answer, yes. And I can continue reading, Your Honor, but nowhere does my client say that this was taken on February 24, 2018. She doesn't reference a date. And Mr. Rosen represented this to you twice last Wednesday, that the court was advised and everybody was advised that it was on February 24th of 2018. He later said she testified that she got this picture taken on the same day. She testified under oath that at 6 p.m., he just said 6:30, on February 24th, 2018, that this picture was taken. That's absolutely false, Your Honor. I'd be happy to provide a copy of the transcript.
He's trying to be a slime ball attorney. He's a slime ball
And
attorney.
one other thing, Your Honor,
Go ahead.
my
I would
understanding of
hate to
California
have
law
a
is that
case
we can't
against
take
him
judicial
any day,
notice of the
man.
truth of the
He's
contents
slime
of the
ball.
website. And there is case law on point I could refer the court to.
Well, I'm not necessarily worried about that. I'm just worried about whether, I don't think that there was any representations of the date it was taken. She did just reference it generally, but the substance of the testimony was that she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material.
Can I respond?
Go ahead.
So,
Hey, Reeve. How are you?
the purpose of this is really not to make anybody right or wrong. The purpose of judicial notice.
Oh,
is
shut
to
up.
clarify when the
You
All-Star
want to be
game took
right,
place.
and you're not right. You're wrong.
And the second half of it is when the photograph was taken. There's overwhelming
Doing good.
evidence attached from different news outlets. There's
Again, is it material, the date? She said she had those nails for the entire week.
It's material, Your Honor, because the defendant testified.
No,
that
she didn't
that's
testify
what
to
she
that,
was wearing
dude.
later in the day.
She said she
That
had
same
them
day.
on all
She
that
had those
week.
nails. You have testimony all over the place about the fact that this photograph was taken on the same day of the All-Star
Yeah, I
game,
just
the
went
same
live.
day of the
Let's turn around, Cardi.
What was the error there is
Turn
that the All-Star
around,
game
girlfriend.
was on February 18th of 2018, and the court said that we didn't have credit.
Is the belly showing? I didn't see the belly.
So that's
I
why
would have been with
the judicial
red.
notice was
Let me down.
prepared so that the court can
Let me down.
see for itself that the All-Star game was on February 18th of 2018.
Okay, I'm gonna deny the request for judicial notice. All right, are we otherwise ready?
There's one more thing, Your Honor.
Go ahead.
He said no,
he asked,
bitch.
the court asked that
Sit
I
down.
prepare a statement regarding the death of John Sherritt.
Okay. You have that?
Looks
Yes,
really
I
pretty
did. I
today.
did give it to the court. It would say plaintiff testified that she treated with John Sherritt MD in relation to this case.
I'm
in
guessing that's the
2018.
same black
It's
wig that she
undisputed
put
that
up.
Dr.
Had
Sherritt died
put up
on March 5th,
as an update.
2020.
Her backside is pregnant,
After a lot of back and forth, what we agreed to, and I agreed
or
to,
it hurts.
was that the court
Well,
could
yeah.
instruct
I mean, if she's
the jury
pregnant,
that it is undisputed that Dr. Sherritt died, period. This March 5th, 2021 date, it's not in evidence. Plaintiff didn't testify to that. She said she understood he died sometime in
hold on. After his
2021.
argument,
She also testified, and we launched the transcripts, I can cite to where in the transcript she says it. Page 148, lines 12 through 149, line 15, she says that she went to see a Dr. Sher, and he told her not to have any treatment. So this assertion that plaintiff testified that she treated with John Sher is not supported by the evidence. It is the March 5, 2021 date is not supported by the evidence. The only portion of this that is actually what I agreed to was it is undisputed that Dr. Sher died, period.
Okay.
oh, he's at it off.
This is what I would propose reading.
Oh.
Plaintiff testified that
That slime ball dude. Okay, anyways. So right now, Reef, they are going through jury instructions. The final jury instructions. So the jury can deliberate after lunch. So we're still kind of waiting until we get the show on the road. And it's closings. It will be slime ball attorney first, and then Cardi's attorneys will go, and then lunch, and then then we'll be on verdict watch, basically. So after lunch, I will be back, unless they and I don't know. We'll see.
she treated with John Sher MD does not dispute that Dr. Sher has passed away.
Your Honor, she did not testify she treated with Dr. Sher. She sought medical treatment. This is page 148, line 12 through 14. Around that time, unclear when that is, did you also seek medical treatment from Dr. John Sher? I did. And then at line 22, and when you saw him, did he advise you that you needed to wait at least 1 year? He did. So that goes on page 149.
So I will read plaintiff sought treatment with John Sher. It does not dispute that he's passed away.
Well, plaintiff testified she sought.
Very good.
Thank you, Your Honor.
What will we read, Your Honor?
Plaintiff testified that she sought treatment with John Sher MD. It does not dispute that he has passed away.
Thank you, Your Honor.
Okay.
Yeah, I'm over it
Well,
too,
there's a couple
Cardi.
things. In
I'm
my
with
closing
you.
argument, I need the verdict form.
So
I
if you ever
can't
put
start
on
out
your
we're working on
makeup,
it.
they
that in
didn't
hand.
match
The
your.
other thing I
Never
want
mind.
to
Let
say,
me.
Your Honor, is
It's something critical.
Your
She looks
Your
better
Honor
than
did
me.
allow me to argue and clarify the NBA All-Star game, when it was, the photograph. I want to be very clear that I intend to argue that in a closing.
It's not in evidence. I think what you said was they didn't provide the date. And you're fine, you can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing,
You could argue it. You could argue that they didn't establish what the date was.
and also that the All-Star game was on February 18, 2018, the week before.
Well, it's like
The week before the incident. I don't see.
that doctor said,
They can object.
because
to that. They
I
say
bet
their
you he
version.
didn't check
That's
take
part of my
any
closing,
pictures.
Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. It was never produced in the
Okay.
record.
That's what's concerning to
Just
me
a
is she
couple of
waited
questions.
4
First-
years to even have one picture taken of her face. One picture. You know, I mean, if I'm suing for millions of dollars, I'm damn sure taking a picture of it that day. You know, I mean, I'm doing that. But she didn't do that. She thinks, oh, let me just wait all this time and they're not going to question me. Because, you know, I was a security guard, you know, high and mighty, thinks that, you know, somebody should bend over and pay for her. No. Cardi works hard for her freaking money and she shouldn't have to give it to people when they start shit. That's not right.
As if you remember,
Should have never gone in that profession in the first place, lady. You're kind of psycho.
Assaul violated a motion to eliminate order. And now he's talking about arguing things that are not in evidence, which is completely improper. I don't want to object every 5 minutes to this argument. I would ask that at least let me say, if the court doesn't want to tell him, that he has to follow the rules. He can't argue out things that are in evidence. He can't violate the motion to eliminate.
He's just trying to be
I
a
think it's
sleazeball.
readily apparent that you can't argue facts that aren't in evidence. I think plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside.
Yeah, outside of the. Yeah, he was trying to do that anyway.
You want to object? And
He's a
that's how we'll proceed.
dipshit.
Thank you, Your Honor.
Would
And
be
then,
the same. Are you done?
then two procedural questions. Does the second monitor work and can it be facing the jury so they can clearly see it?
I don't think so. We're in the middle of a transition and I don't know.
Okay. And
We can see, it's not.
Your Honor's preference, we have demonstratives and we have things we're going to show, intend to show. Do we need permission to publish admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay. I just want to make sure. Thank you, Your Honor.
All right, anything else from plaintiff's
See,
counsel?
he's very
Yes,
respectful
Your
in that
Honor. I
courtroom.
feel that what counsel has just stated is really below the belt and disrespectful to my side. Never arguing things that are outside
Of
evidence.
course, you're such a
No, I
crybaby.
didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the day.
Correct. Your position on Wednesday was that they didn't establish the right date. And you can make that argument.
That's exactly what I wanted to do.
Okay.
Thank you very much, Your Honor.
All right, are we ready to move to the jury?
I must have the verdict form before I start.
All right.
They're being printed right now.
Okay.
I want to argue that this was the wrong day. Who cares? I mean, it was okay. The NBA All Stars are a whole week, not just the weekend. It just livens up during the weekend. Like they have fan weeks and all stuff. What? Yeah, I do. I know a jokey. Right. The slim, I mean, he wants to argue about a picture? Like, give me a fudging break. So crazy to me. You talked about your client in a disparaging way. That was just wrong. Oh, What are you saying that? Oh, she was going through mental
All right, welcome back,
issues when she
everyone. We're
went
still on the
to
record in the Ellis matter.
vaginal
We now have the
discharge.
defendant with us
But
as
that's
well as the members of our
awesome.
jury and our alternate. Uh, Based on the fact that you're all here, I'm assuming no one hit the lotto over the weekend. Folks, we thank you for your patience. We did have a few procedural issues that we needed to address prior to bringing you in. We are now ready to proceed with the last batch of jury instructions. I'll try to.
To me, and Jokey sounds more like she's got a deeper voice. I think Misty has a little bit of a higher voice, but you never know because people be on here, disguising their voices every day. They be one character this day and the other character that day, and Lord have mercy, I couldn't do it. It couldn't be me. But she kind of like roasts like her. She does kind of roast like her. But Misty said she was in the black sector and T sector and all over sectors. I mean, she said she's a sector whore like I am, where we lay our chat as our home. So, hey. And is it jokey in California? That's another thing, too.
Give context to these to the extent that it's necessary. I will put them into the package where they belong, but I do need to give these to you. And we're going to...
The new lemon lady, her name is Misty. She dragged the fuck out of Krista for like hours last night. Like I went to sleep, woke up, seen them still live, and she was still going at it with Krista. Yeah, she got some stamina, baby. I will say that.
Relieve the court reporter of her obligations to report these by stipulation of the parties. Okay, here we go. Words alone, however threatening, do not amount to an assault. Aggressive and threatening actions do not constitute an assault unless they were intended to cause immediate, harmful, or offensive contact. If you decide that Ms. Almanzar assaulted or battered Ms. Ellis, you should fine for Ms. Almanzar if you decide that Ms. Almanzar was acting in self-defense. To succeed, Ms. Almanzar must prove both of the following by a preponderance of evidence: that Ms. Almanzar reasonably believed that Ms. Ellis was going to harm her, and that Ms. Almanzar used only the amount of force that was reasonably necessary to protect herself. Ms. Almanzar claims that Ms. Ellis's own negligence caused or contributed to Ms. Ellis's claimed harm. To succeed on this claim, Ms. Almanzar must prove both of the following: that Ms. Ellis was negligent and that Ms. Ellis's negligence was a substantial factor in causing Ms. Ellis's harm. If Ms. Almanzar proves the above, Ms. Ellis's damages are reduced by your determination of the percentage of Ms. Ellis's responsibility. I will calculate the actual reduction. Ms. Ellis may only establish her claim for negligence if she proves that Ms. Almanzar engaged in negligent conduct that caused Ms. Ellis to suffer physical injuries. If Ms. Ellis can prove that Ms. Almanzar caused her to suffer only emotional injuries, and this is under the negligence cause of action, Ms. Ellis cannot establish her claim for negligence. Emotional distress includes suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, or shame. Ms. Ellis claims that Ms. Almanzar assaulted her. To establish this claim, Ms. Ellis must prove all of the following: that Ms. Almanzar acted with the intent to cause harmful or offensive contact, that Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner, that Ms. Ellis did not consent to the conduct, that Ms. Ellis was harmed, and that Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. A touching is offensive if it offends a reasonable sense of personal dignity. Words alone do not amount to an assault. Outrageous conduct is so extreme that it goes beyond all possible bounds.
Do you get that, people? Just because somebody says words to you doesn't equal assault. I mean, shit. It can be abusive, but it doesn't equal assault. So she lost there. She lost. Right there, she lost. Yep, you
Decency.
lost.
Conduct is outrageous if a reasonable person would regard the conduct as intolerable in a civilized society. Outrageous conduct does not include insults, threats, indignities, annoyances, hurt feelings, petty oppressions, bad manners, or other trivialities that a reasonable person is expected to endure. Outrageous conduct also does not extend to profanity, obscenity, or abusive language without circumstances of aggravation. In deciding whether defendant's conduct was outrageous, you may consider, among other factors, the following: whether defendant abused a position of authority or a relationship that gave her real or apparent power to affect plaintiff's interests, whether defendant knew that plaintiff was
Yes, she does.
particularly vulnerable to emotional distress, and whether Ms. Almanzar knew that her conduct would likely result in harm due to mental distress. Under factor A, which is
Hey, you should just call her Cardi B because that's what she's been what she's been referred to the whole trial. I mean, why not just call her Cardi B? But yes, she just suing for money, and this jury instruction is really pissing me off. But anyways, yes.
the position of authority. Examples of positions of authority or relationships of power include an employer to his employee, an insurer to its insured, a landlord to his or her tenant, a hospital to its patients, an attorney to his or her client, or a religious institution to its members. Ms. Almanzar acted with reckless disregard in causing Ms. Ellis's emotional distress if Ms. Almanzar knew that emotional distress would probably result from her conduct, or Ms. Almanzar gave little or no thought to the probable effects of her conduct. If you decide that Amani Ellis suffered damages that will continue for the rest of her life, you must determine how long she will probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another 50 years. This is the average life expectancy. Some people live longer, others die sooner. The published information is evidence of how long a person is likely to live, but is not conclusive. In deciding a person's life expectancy, you should also consider, among other factors, that person's health, habits, activities, lifestyle, and occupation. Ms. Ellis seeks damages from Ms. Almanzar under more than one legal theory. However, each item of damages may be awarded only once, regardless of the number of legal theories alleged. You will be asked to decide whether Ms. Almanzar is liable to Ms. Ellis under the following legal theories: battery, assault, intentional infliction of emotional distress, and negligence. Ms. Ellis's claimed damages are recoverable only once under all of the above legal theories. And the verdict form breaks that down for you. The following are specific items of non-economic damages claimed by Amani Ellis: physical pain, mental suffering, and emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, emotional distress, Amani Ellis must prove that they are reasonably certain to suffer that harm. For future physical pain, actually, I think, okay, no, we're fine. For future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress, determine the amount in current dollars paid at the time of the judgment that will compensate Amani Ellis for that future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, and humiliation, and emotional distress. If you decide that Ms. Almanzar's conduct caused Ms. Ellis's harm, you must decide whether that conduct justifies an award of punitive damages against Ms. Almanzar. The amount of punitive damages, if any, will be decided later. You may award punitive damages against the defendant only if plaintiff proves by clear and convincing evidence that Ms. Almanzar engaged in that conduct with malice, oppression, or fraud. If you define that defendant accidentally harmed plaintiff, punitive damages are not appropriate and should not be awarded. In deciding whether or not to award punitive damages against the defendant, you may consider whether defendant's acts were the consequence of a sudden heat of passion that was provoked by plaintiff. Malice means that defendant acted with intent to cause injury, or that a defendant's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A defendant acts with knowing disregard when a defendant is aware of the probable dangerous consequences of her conduct and deliberately fails to avoid those consequences. Oppression means that a defendant's conduct was despicable and subjected the plaintiff to cruel and unjust hardship in knowing disregard of the plaintiff's rights. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that the defendant intentionally misrepresented or concealed a material fact and did so intending to harm the plaintiff. During the trial, plaintiff testified that she sought treatment from John Scher, MD. It is not in dispute that Dr. Scher has passed away. All right, ladies and gentlemen, that concludes the additional jury instruction, and we're back on the record with the court reporter. That concludes the additional jury instructions that we are adding to those instructions that I previously read. At this point in time, it is the time for the attorneys to give you their closing arguments. Please keep in mind my instructions regarding the facts in this case. You are the ones who are to determine the facts, and to the extent that the attorneys argue facts that you do not believe were proven during the trial, please rely on your own finding of what the facts are. And similarly, to the extent that the attorneys argue law that is contrary to the law that I've just given you, please rely on the law that I gave you. And with that, is plaintiff prepared to give your closing argument?
Yes, Your Honor. I'll just ask for a quick sidebar for a moment, please.
All right, we had a brief conversation at sidebar, and now is plaintiff prepared to proceed with your closing argument as soon as you get there?
Yes, Your Honor. Thank you very much.
And just for any members of the gallery, if you are not a member of the press and you don't have a sheriff's badge as well, you're not allowed to use any electronic devices or phones. Thank you for that.
Yeah, no taking pictures of Cardi while she's in court. You might, Cardi might see you instead.
You all for coming back today. So at this point, both sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different. And what that means is, in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses
All of them had attitudes.
Their
Not very
recollection
likable on
about
the
the
stand.
scar. There was testimony that the
Except
scar
for grandma.
or the cut came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when
the way that this
Throw that at
scar-
him. He's an
the way that this
expert.
cut
He was
happened
lying
was
to
from
you.
fingernails, and that there were 3 different scrapes, 3 different scratches, and that the middle one was the deepest one, and that's really the one that he worked on. Now, the issue in this case is, well, before I go to that, is the photograph that you saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else.
What?
The other thing
Do you
I
believe
wanted to
that?
highlight
Do you really
is-
believe that in yourself?
I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F-word,
you
B-word,
asked
all
her.
these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss Ellis, just because Miss Almanzar, also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people. Okay, if you recall, just to give you a little bit of background about Miss
Cardi,
Ellis.
I feel you, boo. I feel
When
you.
she was 19 years old, she moved out of her house. She went to college.
Who
She's a
cares?
college graduate. She has a bachelor's.
Doesn't mean she's not a fucking liar. Okay, let me
She
go back on you.
went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard, and she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me.
I'd
Maybe
be
he's
doing the
that
same
because he's a
shit,
psychiatrist
though.
and he knows what to say to twist everything. But the point is, he got.
I don't blame her for doing this, for acting like this, because I would, I'm with her. I'm so with her. Like, you're just sitting there lying on me. Like, you told me what was said, sir. And you're saying I broke the rules. The judge would have stopped me if I was breaking the rules. Anytime you try to spell it out or whatever, they say, use your words. They tell you to use the foul language if it's in the sentence. Or if it's how things were, being communicated at the time. Like, dude, get off your... See, he's trying to go there. He's trying to be like, oh, well, Cardi just swears in her albums and all this other and says all this derogatory crap. She thought she could just come in here and da-da-da-da-da. No, she's telling you exactly what you told her to tell her. What exactly did she say? She answered. But it's okay. It's okay for your girl to get up there and lie like 300 million times, right? Okay, cool.
$40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are,
Cardi,
Imani Ellis was working as security
don't
guard.
say it, girl.
There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that
This is
Miss Imani Ellis suffered.
This is ridiculous. Let's get the sympathy vote in there.
Now, in this case, there was overwhelming testimony that Miss
I
Ellis
remember the
was
incident.
working as a security
I
guard.
remember the incident.
At the
That's
time
why I
of the
said
incident. There's no
Cardi's
question.
not guilty.
She was in full uniform. She
Tried
had
to
a
sell that
badge on.
freaking video to TMZ.
Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you know, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. They were all ignored.
What? What, dude?
Instead, the defendant thought that, well, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her
And
head
I bet you,
at the time. And she's
because she
testified.
was. Even the freaking
However, that's not the case.
receptionist
Miss
and the
Ellis
doctor said it.
testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also.
And your
She's a
parents
model
don't know
citizen.
everything the
She's
fuck
a
you
hardworking
do.
person.
Give
And
me
she's
a break.
simply, her whole
With her,
goal
if
of-
she had that attitude her whole life, the way she acted on the stand, if she guaranteed she was in fights. I guarantee she was in fights.
doing this, to be here and sit here and go through this, is so she could move on with her life. Sometimes people have to be heard.
See, I'm not really hearing like what yeah, I'm not really not hearing a case. Like you're not helping your client. Okay. Maybe the jurors saw a different case than we did. Maybe that's it. Yeah.
Be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can.
Right, like he didn't even write the shit down. Like he's all over the place. He doesn't know what the fuck to say. Oh, let me go ahead and sit here and belittle the defense and all that other dumb shit. And let me say, oh, all this money. Well, she has that money to spend, dude. Like, hello. Like she said, hello.
Move on and go on to the next step and the next phase. She's only 32 years old and she has plans. She has plans to do other things in her
Cardi. And
so we're very thankful that you gave us that.
Plans? Yeah, she has plans because she figured this would be a quick payday since workman's comp was denied. Give me a break, dude. Give me a
Opportunity. Each and every one of you. We're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is recording video is not available while on the call. So it couldn't be. The two of them couldn't be done at the same time. Miss Ellis told CardiB multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, CardiB got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words, using the N word to disrespect her, calling her the B word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher a sentence that basically that it's undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who's another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor.
System.
Then we learned throughout the case that when CardiB came to the building,
Yeah.
she caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming to the point where 2 other witnesses, Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke, was so loud that those 2 people came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't see the 4 things that happened before that, which happened in the 40 to 50 seconds.
Oh, yeah. Oh, yeah.
So, yes, they're witnesses, but they're not witnesses
They are
to
witnesses.
that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those 2 witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know.
No, they're
what really
eyewitnesses, dude.
happened. And when they arrived,
they're definitely after the
Miss
fact.
Ellis
too.
was so upset. Can you imagine all those 4 things happening, being disrespected, embarrassed? Who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was angry. She was emotional. So when these 2 witnesses come out of their office,
Cardi ain't having it.
they can only see an angry person. They didn't see what led up to that, and they had assumed that it's her fault, maybe, or that she did something wrong. But again, those 2 witnesses didn't really see much. They saw something after the fact.
You're not supposed to be.
And then you have Miss Malcolm, who decided on her own.
What you call
This
it?
was her choice to squeeze herself in between the 2 people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something,
Don't fall asleep,
well,
Cardi.
we don't know who did that. We really don't know. She didn't even know.
Yes.
Miss Malcolm testified that she did not know who scratched her face. She has no idea.
You know,
What does
plus
that mean?
she's
It could be
got
from
3
either
little
one.
ones.
It could be
so.
from the commotion that's going on. These things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera. There was no
Don't
other
fall
witnesses
asleep, Cardi.
that actually saw it. So it really comes down to one thing. Do you believe Miss Ellis? Why not? You should. She's a hard-working security guard. She was doing her job with no prior anything.
Objection. System.
At some point during the trial, the defendant showed you Exhibit 232. You all remember this photograph? Exhibit 232. This is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection. Overruled.
There is no proof of when this photograph was taken. It could have been taken at any time, before or after the incident. It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor.
That was her testimony. But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken.
You don't take the photograph,
All-Star
dummy.
NBA All-Star game. There's no proof of that anywhere. That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely on this photograph because there's no date on this photograph.
Oh my God. Well, what about your girls? What about hers? Let's talk about her pictures. Why wasn't a picture taken of her that day? And of course, she got rid of the phone because the phone had the freaking stupid the video on of her in the freaking doctors. That she could have fucking fixed her damn self at home. What is she, too wussy? She can't handle the pain. Obviously, she can't handle the pain.
Is she made an incident report. 2 days after the incident, Miss Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. And she did follow
and what's
company
funny
policy and
is, hey,
did
guess
what they
what?
asked her to do.
Guess what? You're using the defenses, the defense. They brought out that email, not you, sir. But you're going to go ahead and use their evidence? Dude. What? When asked about the email, I wasn't, I'm not attached to any emails like that. Some shit like that. Some weird shit. Weird.
She called her supervisor, made an incident report, and did everything possible to document all of the different things that happened to her on that date of February 24th, 2018. The other important issue is CardiB testified that she came to the building, at least downstairs at the building. She had a security guard with her, Mr. Newton.
What does it
Mr. Newton,
matter
that's
about
her
the security guard? You're so
He didn't
hung up
testify in
on the
this case.
security guard,
Why not?
dude.
Where is he? Disappeared? Miss Ellis testified that when she saw
He wasn't
this
a witness.
security guard downstairs in the lobby, she
Duh.
met with him there. Mr. Newton apologized for what happened. Mr. Newton should have testified in this case and could have testified in this case.
Well, then why didn't you call him?
And there is a
Why
jury
didn't you call him,
instruction,
sir?
KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So where's Mr. Newton? I don't know. He was on the
You
witness
didn't
list.
call him.
He should have came here and testified.
I knew he was going to bring up that security guard. I knew it. I just had that feeling in my bones. Cardi has had enough with him, though.
Another important fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case.
Don't you worry.
And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact. You initially heard that Ms. Ellis saw the Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple of reasons. One is you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years, to determine if the scar will become a keloid. I'm sorry, if the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed.
Oh my God, of course.
Elective surgery. So the case was delayed. The medical treatment was delayed. That's why Miss Ellis waited. Another factor is affordability. She had to find a doctor.
What happened to the 2 years before that?
Was willing to work on a lean basis. Dr. Mulliken testified that he would agree that he treated her on a lean basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient.
So 4 years, she waited. Okay, by technicality, we'll say, okay, yeah, let's go ahead and wipe the freaking COVID out, right? Okay. But why did she wait 4 more years to even be seen by a doctor? Tell me that, sir. Freaking kidding me?
Delay payment. They delay getting paid. That's what Dr. Mulliken did.
Did he really watch the same trial? Maybe he didn't. Maybe he didn't.
Dr. Mulliken testified that he fully examined Miss Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Miss Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months so that Miss Ellis could there were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also, as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind.
Lord, you couldn't see it, dude.
Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry. Oh.
And in this case, the defendant decided not to hire one. So what does that mean?
She shouldn't.
What that means is you really got to take what Dr. Mulliken says with a lot of importance, a lot of truth. There is no other doctor.
No. So
on the defense side, they could have spent money and hired somebody to testify here and tell us, yeah, Dr. Mulliken's work is.
We don't know where it came from, sir.
We don't have that here. You have one doctor on the plaintiff's side basically explaining all of his expert opinions. And he's a board certified plastic surgeon for 30 years. He's affiliated with UCLA and even testified that he, in his career currently, does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves. Now, when you go back,
like you don't even believe in your case.
when you go
Like, you're
back
not
into the
putting out a
jury
conviction
room,
like you really need.
you'll see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room, so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases, working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact.
And that don't mean shit. A little money can sway anybody.
The other thing that I wanted to
You act like just
discuss
because
would
they
be
hold
the
a
fingernails. The CardiB
career,
testified that most of the time
they can't be slam bally.
she would have long fingernails of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones.
He can't tell you what
protruding. They were raised.
So you need to stop that shit real quick. Lying.
When CardiB testified, she
guess what?
acknowledged that she refused to listen to Miss Ellis, who was
closing argument is an evidence, sir.
There was also testimony by CardiB that the two of them were chest to chest touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to CardiB physically, but CardiB made that
Give me a break.
And that's an unlawful touching.
Okay, let me.
That alone, aside from the rest, that alone, CardiB admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. CardiB even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony. When Miss Ellis told CardiB to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors. CardiB refused to listen to the security guard who was working there. At some point, CardiB caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified. She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor.
Miss Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge.
Oh my God, he embarrassed her again.
Dr. Rosenberg testified that there was an inconsistency.
Oh my God. You are such a piece. Oh, how embarrassing. First, you make me bring this lawsuit, and second of all, you just disclosed about my vaginal discharge. You know, a lot of people are going to speculate what that vaginal discharge meant.
When Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life.
No.
Some of the doctors will even say, don't tell me. I don't
sir.
want
to. No. Every time you go to the doctor, they make you fill out that depression anxiety freaking sheet to see how you're doing, to write it in their notes just in case. Because if you're having those issues, that could possibly be the reason for your other issues and stuff like that, sir. They make you do it every freaking time you go to the hospital. Or doctor, whatever.
No, I'm not writing it down. We've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022 and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser, she didn't tell him about the emotional injuries, it just doesn't make sense. I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If a third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case to, in a sense, to muddy the waters, to kind of cloud what really happened. What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And CardiB came along and thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, you got to be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But again, same problem with him is when he came, everything had already been done. The whole incident already happened. The injury was already complete. And really, this comes down to believing Miss Ellis. She gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure. And yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by CardiB, and CardiB needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again. Now, in addition to seeing the two plastic surgeons and Dr. McKinsey, Miss Ellis also received another 12 visits of, she testified that she saw a psychologist, Dr. Avila, and other
Objection, Your Honor.
people in his office.
Violation of the court's order.
Move on. The other thing that CardiB failed to do or could have done is she could have filed a cross complaint.
Objection, Your Honor.
All right, and then I want to go over a little bit about the medical bills. So you don't have to get it exact, it doesn't have to be an exact number. But there was testimony in this case that Miss Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.
There was also testimony from Dr. Mulliken that he believed Miss Ellis could benefit from one more surgical procedure, another one, to make it better. The cost of that was $15,000.
Objection, Your Honor.
The $15,000 that would be paid for that would, in Dr. Mulliken's expert opinion, it would make the scar better, meaning it would reduce, it would, basically what I'm saying is there's still some scar on her face. And if you want to look at it, you're more than welcome. You can have her walk around. You can look at it for yourself. There is still some scar on her face. It's still there. It still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000 for the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things. All of the things that happened to Miss Ellis are they're wrong. And we want to make this wrong right. And how can we do that? For each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now for today's purposes is to reimburse her for the losses that she sustained. Those are the medical bills, the past, and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering. In every case where there's medical bills and there's medical damages, component of that is pain and suffering. There is really no way, there's no exact math to that. So for instance, if you said, I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering. You are allowed to do that. It is a number that you can come up with. During the 7.5 years that she's been suffering, you may say, I would like to give her $100 a day. For 1 year, that's $36,000. And for 7 years, that comes up to $270,000. We're not looking for millions of dollars like the defendant said. That's not what we're looking for. We're really looking for a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do. So when you go into the jury room, you'll be given a verdict form. And the verdict form will basically state, it covers all of the different areas of this case. The first section A is the assault and battery. They are in a sense separate because the assault is the swing and the battery is the scratch and the cut to her face. However, it's very clear. Did plaintiff Imani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis Marlenis Almanzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or offended by Miss Almanzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side, it's not broken down into 4 parts. It's all as a whole. So if you want to give money damages to Miss Ellis, you would check yes. Okay, and then you go to the next question. Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Miss Ellis did not consent to Miss Almanzar's conduct. Miss Ellis was harmed, and Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. Again, if you want to give her money damages, you would check yes. That would be page 2, both of those. Then you have question number 3. Did Miss Almanzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almanzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almanzar herself, her position was, I didn't touch anybody and nobody touched me. So self-defense, no. You would say no. Then you can go, then question number 4 speaks about the damages that she suffered. Past medical expenses. That's where you would put in an amount of money through the testimony that you heard and through all of the exhibits. You would put an amount of money that you believe Miss Ellis incurred in this incident. So you will have in the jury room exhibit number 4. You'll have exhibit number 4, it's been marked at the bottom right corner. You will have exhibit 4-1 through exhibit 4-6, and then it will skip over and you will go to the bills, which will be 4-13, 4-14, and 4-15. If you combine all of these bills, you will get $16,500. So past medical expenses would be $16,500. That would be what you would write there if you want to give her the cost of all the plastic surgery she had to go through up until now. The future economic loss is the future plastic surgery. Dr. Mulliken stated that Miss Ellis would benefit from a future plastic surgery of $15,000. So you would write $15,000 in that box. Pain and suffering. Again, there's past pain and suffering and future pain and suffering.
Lord have mercy.
The court read a time frame for you of how many more years Miss Ellis will live. And the jury instruction life expectancy, 3932, basically states that Miss Ellis will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have based on all kind of statistics. She has 50 more years to live. So if you feel that she's going to suffer from this point forward, then you can award her money damages for the future. And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5-year time period. And again, you'll all have the jury instructions in the back when you go into the jury room. And the jury instruction on pain and suffering covers a whole bunch of different things. Very important. Very important.
Dude, like, come on.
So I would take a look at that one because it covers all of the different things. Embarrassment, pain and suffering, disfigurement, all of those. So if you look at 3905, it talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that.
Or give her none, because she deserves none. 500,000, whatever.
So for past non-economic loss,
I'm glad you didn't put 24 mil or something.
you should put a number there. Because if you don't,
She lost her.
the award will be thrown out. You got to have at least $1 there. You got to award some kind of pain and suffering. It's required. Now, the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bumps and bruises. This is a serious, serious injury, very serious. And Miss Ellis has been suffering for the last 7.5 years. What kind of weight do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for example, you could write $250,000 for the past pain and suffering. This was a violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment that she didn't have to go to.
She also had 2
So much
accidents.
life was lost.
You don't know where that scar came
time-wise.
from.
You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic. We all went through the pandemic, and we realized that after the pandemic, the value of life is much greater because we realized what life is really about.
Oh my God.
Future non-economic loss. Again, that's going to be for the 50 years going forward. You
She ain't lose nothing.
pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is. But you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number 1, Miss Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. Miss Almanzar intended to cause Miss Ellis emotional distress. Miss Ellis suffered severe emotional distress, and Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then number 6, again, it says, did Miss Almanzar prove all of the following elements of the privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress. Then number 7 has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is if you feel there should be separate damages aside from the assault and battery for the emotional distress, then this is where you can give that amount of money. It'll be a separate and apart damage area for you to award more damages. Same breakdown. You can give past medical expenses, obviously past and future medical expenses. In this, if you're awarded in the first box, then you would say 0 and 0 because we're not double dipping here. That's not our goal. However, pain and suffering. if you want to give separate pain and suffering for the emotional distress, separate pain and suffering for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give 50,000 additional for the past, 50,000 additional for the future, and then we're going to move on to the last part, which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury room. And I'll close with this. Did Miss Ellis prove all of the following elements of the negligence? Miss Almanzar was negligent. Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almanzar, was Cardi B negligent in thinking that the plaintiff was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almanzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then again, it asks for the damages. Same thing. 0 and 0 for the past and future medical expenses if you have given it in the first phase. So there's different areas. Maybe you'll say, well, I don't really believe there was this, but I believe there was that. So anywhere on the form, we would ask that you award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair for all the things she went through, the assault, the battery, the emotional distress, all that she should be compensated for. And then there's a box, did Miss Almanzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then it goes to number 11. What percentage of responsibility for Miss Ellis's harm do
She
you
didn't do
assign to
nothing
Miss
wrong.
Almanzar?
She wouldn't have lost her job, dude.
100%. And Miss Ellis, 0. And the final page deals with punitive damages. Did you answer question 4 or 7? You look back, and if you did, which is the damages, then you put yes. And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almanzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Miss Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here. So at this point, I'm going to turn it over to my counterpart. They will obviously contradict everything I will say. I've told you. And then I will have a chance to come back and rebuttal and clean up anything that was said. At this point, I'm basically Miss Ellis's mouthpiece, and I worked with her as best I could to convey all of the things that she wants you to know. I worked with her personally to tell you all what she went through, and I did the best that I could with what I have. And we really, no matter what happens, whatever is supposed to happen will happen. because that's what's supposed to happen. And we want to thank you each individually for being here. Each of you as individual judges, we're thanking you very much. Thank you so much for hearing the story as to what Miss Imani Ellis went through. And I'm asking you to award Miss Ellis an amount of money that you think is fair that will make her whole for the losses that she suffered in this case. Thank you very much.
All right, thank you, counsel.
Why didn't you say the $24 million like
Okay, all right.
you wanted to?
Defense ready to proceed?
We are, but I would think a break would be appropriate.
Does anyone want a break? We got started late. Okay, why don't we take a short break? Why don't we resume back at 11:25? In the meantime, please not discuss the case with anyone.
Oh, thank goodness I got some time to
Or
go
do
through
any research. We'll
these.
see you at 10:25. Or, I'm sorry, 11:25.
Did they say anything after this? Let's see. Hello?
One note, and is this grandmother here?
Yes.
Ma'am, can I have you step forward? Can I have you step forward? And ma'am, you were previously sworn. You understand you're still under oath? Sure. Did you have any conversations with alternate number 1 on Wednesday? The woman on the corner? The woman who's on the jury? No. You don't recall any interaction with her?
She sat next to me and she was waiting on a break, but we didn't speak.
You didn't speak with her? Okay. So you didn't talk to her about the trial at all?
Absolutely not.
Okay. All right. You were just seeing, we thought that there may have been some discussion between the two of you. You don't recall that? Okay. All right. Thank you. All right. Something else?
Yes, Your Honor. Although you cautioned counsel that he can't argue things that are not in the evidence, he repeatedly did. He even started talking about Dr. Avila's treatment, even though he was excluded, over and over and over again. And all the jury sees is me objecting and Your Honor sustaining it. I would request that you admonish the jury to disregard all of the statements that you sustained objections to. I would also ask that you assign this conduct to counsel and that he be reprimanded because this has just been ongoing.
Okay. We can discuss.
I want to respond.
Well, let me do this. I will give further instruction to the jury about that the argument of counsel is not evidence and that they should disregard any comments that were not supported by the evidence. I will give that instruction. We can discuss whether or not we want to set an OSC after the trial for any alleged conduct. Okay.
Thank you.
Your Honor, may I please say one thing?
Yeah.
Please.
Go ahead.
I just want to note that you advised Mr. Rosen that if he were to argue to the jury that Cardi said that photograph was taken on February 24th, that would be a knowing violation of the professional rules, and that's exactly what he did.
Okay.
Yeah,
Well,
I wanna respond.
why don't we? I don't want to do it now.
Well, I have to say something about it.
You don't. I said we'll discuss whether or not we want to set an OSC and we can address it then. Okay.
Thank you, Your Honor.
All right.
Shouldn't try to be a slime ball attorney. Goodness gracious, what the fetch going on? Woohoo! Whoop boop boo. Come on, baby.
All right.
Now we're back in
We're
action.
back in the record in the Ellis matter. Counsel and the parties are present, as are the members of our jury and our alternate.
Now it's the
And,
defendants.
Before we get started with the defense closing argument, you heard a number of objections during plaintiff's closing. Some were procedural or evidentiary in nature, but some of them were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections. To the extent that plaintiff's counsel mentioned any facts that weren't presented in evidence during the trial, please disregard any and all of those facts that he represented that weren't actually accepted into evidence during the trial. Okay? All right. With that, defense can you give their closing?
Thank you. Good morning, everyone. I'd like to start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that is just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statements, I told you what I expected the evidence would be, and I told you that you can treat my statements and counsel's statements as promises of what they were going to show, and that I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in, witnesses have testified, that exhibits have been admitted, and if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case, and that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more, her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated on this slide. That's 50-50. That's where the plaintiff has put on as much evidence as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%, she starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway. at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has. That arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear. In fact, that would be crazy that someone could sue if they cause someone else to use profanity. The question really is whether Cardi ever struck plaintiff, and who caused this confrontation? Who caused the incident? And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence, more likely than not, that Cardi was the cause. The way, I'm going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart. And so we have on the left-hand side plaintiff's evidence, and then on the right-hand side defendant's evidence. Now, plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom were present at this very time of the incident. Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true, okay? She has her version, but the fact that she alone says it does not actually make it true. And this later this morning, maybe stretch into afternoon, I'll tell you, or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. But plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report.
Objection, Your Honor.
And she actually testified she did not know if the scratch that has supposedly ruined her life was even bleeding. She also testified last week that she didn't even put a Band-Aid on the scratch. What did she do? She claims that Cardi mauled her, basically, cut her face, and this woman went home, and what did she do? She took a nap. That was her own testimony. She took a nap. The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-bill cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200. She gets calls and and makes calls from 11:20 a.m. all the way to 3:35 p.m. and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021, she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021 is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulligan. She went to plastic surgery 4 years later after being in a car accident.
Objection on this state's testimony.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another lawsuit over that one. Plaintiff has argued, and he said again today that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when CardiB was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower. I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into CardiB in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on CardiB and forced her into a corner in the hallway where Tiara Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Actually, you're not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. We all have relatives and we hope our parents believe us and and our grandparents. But remember what Judge Fusselman said at the very beginning, common sense. Okay. We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything. And they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi, half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say? Guess what, Mom? Guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no. So we know that plaintiff left that part out. Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay. Well, that sure doesn't square with the testimony of Tierra, Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek. But in plaintiff's own incident report, she said she told her supervisor Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Imani Ellis had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday, question, you didn't call your grandmother though, did you? Answer, no. Okay. So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired. And as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses is Dr. Mulliken. And that's what she offered to support her claim. Of course, Dr. Mulliken also wasn't there on February 24, 2018. He didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulliken is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital
Is he not
camera
even taking notes?
before any treatment, sure doesn't appear to show the scar. That is you'll have the actual, a copy of the actual photo
on his computer.
It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you, look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay, that's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask for permission, but we'd like to show the. Okay, then we'll show. This was played for the jury before. It's Cardi's testimony. Excuse me, plaintiff's testimony as to how she was supposedly cut by Cardi.
When you say like this, she put her finger.
Pointing, yes, go like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulliken's testimony that it was a right-handed person who scraped with an index finger and 2 other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have
He's just trying to get the
completely different explanations for the same claim scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulliken says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with the straightened finger. And to add to that, Cardi is not right-handed. I want to say that again. It's very important. Dr. Mulliken says that in his professional opinion, and counsel talked about it, how well-respected he is, that it was a right-handed person who scraped 3 fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that. Plaintiff's counsel tried to get Dr. Mulliken to testify that a left-handed person might have made the claim scar, but that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulliken testified that he can't say when plaintiff got the claim scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulliken. And Dr. Mulliken also testified that he can't say whether the claim scar was caused by an intervening accident or some other cause.
Objection on this case.
Ladies and gentlemen, you heard the evidence. Please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulliken's testimony. For example, he calls a 3-minute long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session in his mind is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing, even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulliken testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive surgery or microneedling. Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulliken also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulliken, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulliken also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulliken. Dr. Mulliken knows that he is going to get paid, if at all, the $17,500, only if his testimony helps plaintiff recover money in this case. That is a big incentive. And because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side. So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018, she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, why does that matter? You're pregnant. No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated, and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned, she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that she got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots and starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, that's my phone. This is my building. You can't tell me what to do. That's what Cardi testified, and it's consistent with what Tierra Malcolm, and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop, please.
I can stop there if you want,
Okay.
Alex.
All right. Why don't we stop there, folks? We're going to resume back at 1:30. In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30.
Really? Really? They're on lunch break. Ain't that some bullshit? Bullshit. By the way, he is like crushing their case, like crushing the plaintiff's case. He's being factual. He's not overstating the freaking the evidence. He's not mischaracterizing their evidence. All that good stuff. Because I would be the same dang way. Anyways, we got some fast forward time. We got 40 minutes. 40 whole minutes. I was hoping that they would be done today, but because they started late because they wanted to add more rules or instructions, it's just done. But yeah, I don't know about this case. I really don't know, because you never know what 9 people are thinking, and that would make me a little bit weary if her grandma was talking to one of the alternates, like, really, lady, come on. That's a mistrial. Shit. Or they just excommunicate him. That's my bloody shoes. Red bottom, Santa Gunner. Okay. Anyway, so now we can sit here and I don't know. I really don't know. I don't know. Because you never know. You never know. But I really don't think Cardi did that. Like, girl got in a car accident too. I don't think Cardi's that stupid to lose her shit like that. But you never know. And why not have proof of it? Like, and a doctor's like, yeah, man, she lost her job because of her own conduct. It wasn't had nothing to do with Cardi. But yeah, what do I wanna? I wanna. What is that damn song? I can't play Cardi. They distract me down. They distract me down. Um, let me see. Let me see if this is the one that I like. Which one is it? Money shoes. Money shoes. Money shoes. Got some money move. Move. Anyways, okay. And I forgot to add my music to this thing. I wish there was a way I could yeah. I'm gonna have to delete that. I'm gonna do another one. Do. Mm, 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 mm. Anywho, come on, Cardi. Maybe I'll come back. Yeah, maybe I'll come back. They won't be back for another hour, so I'll come back. All right, everybody. I will be back for the second half of Cardi's closing arguments. Because I just, when there's nobody in the chat and nobody right here, like, it's hard for me to, like, keep talking to myself. I don't like to keep talking to myself. It makes me feel weird. I'm already weird as it is. Like, it makes me feel even more weird. So yeah, I'm gonna go eat lunch and I'll be back. I will be back. All right, everybody, stay blessed. Have a good one and see you in a minute.